Good afternoon and welcome to the special meeting of the Ethics Commission. This replaces the normal meeting which would have taken place on June 22nd, 2015. I'll call the roll. Commissioner Andrews? Here. Commissioner Hain? Here. Commissioner Herr? Here. Commissioner Keane? Here. All right, the record should reflect that all commissioners are present and accounted for. Item 2, public comment on matters appearing or not appearing on the agenda.
Good afternoon, Chair Renee and members. I'm Patrick Manette-Shaw. 2 conflict of interest ethics complaints against the San Francisco Employee Retirement System member Wendy Paskin Jordan were filed in 2014. The first on April 3rd, 2014. Some people mistakenly think I authored both complaints. I'm not that smart. Didn't know anything about the retirement system until recently. Paskin Jordan admitted on a YouTube made by the Labor Video Project, and I'll give you the video number, that she had aggregated funds with her firm to reach the $10 million threshold for investing in BGI, as the ethics complaints had alleged about her having aggregated funds. This commission needs to ascertain who else she aggregated funds with, and whether she or her investment clients aggregated funds with the city's own retirement system funds. Paskin Jordan claims that as a registered investment advisor, she isn't held to the same minimum investment threshold as other investors. However, several other registered investment advisors have asserted her claim is patently untrue. You should seek external expert legal advice about her claim, because I believe deputy city attorneys are misleading her. Paskin Jordan landed in the San Francisco Examiner shortly after Joe Fitzgerald Rodriguez's story put an end to the sleaze article, reporting on her investment in the BGI fund that SFERS invests in. You need to investigate this thoroughly. You need to move those anonymous complaints forward. If the allegations are true, she should not be sitting as a fiduciary overseeing retirement funds.
Any other public comment?
Hi, good evening. My name's Rebecca Ryan. I'm the Executive Director of the Municipal Executives Association, and I just want to speak for one moment about the Form 700 agenda item. I assume we'll be able to speak on it again under the discussion. I wanted to thank the Ethics Commission for taking it on as a discussion item this evening, because I think it falls squarely into the law of unintended consequences in terms of thinking it through. And I also just wanted to clearly say that MEA is committed to the highest ethical standards in the delivery of service to the public. So this is really about process, not substance, and it's about changing the rules for 3,200 people and making sure that when we do that, we do it thoughtfully, we do it with sensitivity to what it means to their privacy, and we do it in such a way that the rules are clearly understood by a very large group of people, many of whom have not had the benefit of ethics training and do not have, and frankly, may or may not even be appropriately listed as potential filers. So I look forward to your discussion, and again, really appreciate the patience to have the discussion in a way that moves your goal forward effectively. Thank you.
Thank you. Any other public discussion? All right, we will turn to item number 3, which is a discussion regarding draft regulations for electronic filing and website posting of statements of economic interest, Form 700. And I will ask Mr. Minardi to sort of give us some background and fill us in on what the issues are and what's being proposed.
Thank you, Chair Rennie. Jesse Minardi, Deputy Director. This is, as was mentioned before, a discussion item regarding staff's proposed changes to the Form 700 filing obligations for a number of city employees, probably numbering around 3,000 to 3,200. These are people called, referred to as designated employees who have to file a Form 700 disclosing financial interests such as real property interests, income, investments. And these currently are being filed with their departments, these employees' departments. So they're filed with their department. It's kept in a file there. And so earlier this year, the Commission had put on our work plan to expand our electronic filing requirements, which currently apply to members of boards and commissions, elected officials, department heads, where people file electronically and then their statements are posted online with certain information redacted. Expanding that to all filers within the city. And so staff went about crafting regulations to that effect. There are 5 regulations. The first essentially requires filing of these statements electronically. The second requires provides for a waiver for folks who want to file on paper in compelling circumstances. The next requires posting online of the information, as well as a potential waiver request to take down in compelling circumstances, as well as for the redaction of certain information. And then there is a penalty provision, so that if folks did not file electronically when they were supposed to be filing electronically, the Ethics Commission could, in fact, enforce that. So staff drafted this and conducted outreach, these regulations that are before you in the memo. We conducted outreach which consisted of interested persons meeting. We did get feedback, which we summarized for you and there in one of the attachments. But we also did have what's called a meet and discuss with, or we asked for a meet and discuss with union representatives who represent a number of these employees who would file. And we did have a meet and discuss, and at that meeting there were concerns raised about sort of the privacy interests of the city employees. Folks are here and they'll say it better than me, but I think the general sort of concern raised is that there are a number of folks who perhaps should not be filing in the first place, and that there's a difference between sort of those folks having their Form 700s in a file somewhere and posting it online so people can just search it. So after that meeting, there were further concerns raised and requests for a more formal process called a meet and confer. And for that reason, with the Chair's approval, we moved this from an action item to a discussion item. And the hope is, our staff's hope is that feedback can be received from the public, the Commission can talk about it, and the Commission can give staff some direction in terms of whether they generally like the proposal or there are things that they don't like about it, so that we can, in fact, take the next step, meet with union representatives who are interested, and talk about it in an informed way, knowing generally where the Commission is coming from, as opposed to have it be staff's sort of sole idea as to what might be the desirable policy outcome. So that's why we put it on here, and I'd be happy to answer sort of any specific questions. I think the one thing that we are most sort of interested in is the Commission's position on the posting online of these statements, the redaction of information, and also the potential compelling reasons why folks would not have to have their Form 700s filed online.
Let me ask you a question. What is the basis for the present policy of having some of the Form 700s filed with the Ethics Commission and some filed in the various departments? How did that breakdown come about?
Sure. Honestly, I'm not sure. The fact is that that's normally when you have department filers, meaning lower level filers, my experience in most jurisdictions is that they, again, file with their department. People know where to go. And usually these rules were conceived of before electronic filing. So the idea was that people would know where to go if they wanted to know where somebody, where to get that rule.
I'm curious about some determination was made somewhere that elected officials, commissioners, and things like that should file with the Ethics Commission rather than the Board of Supervisors filing with their own and any other group of elected officials or any commission filing their own. And the question is, what was the basis for that breakdown of saying you've got to go to the Ethics Commission at certain levels, but other city employees, it's all right, file them with the various departments?
Commissioner, this process was in place when I got here. It happened before we came, so I don't know what the decision makers were thinking at the time.
But there's no statutory language that says that Form 700, say, of commissioners like us, have to be filed with the Ethics Commission, or that the Board of Supervisors or the city attorneys have to be filed with the Ethics Commission. There's no statutory?
There's two tiers of filers. Tier 1 filers file with the Ethics Commission, and they have to put more information in their forms. Tier 2 people are decision makers, but they're not major decision makers, and so the information that they file is less than Tier 1, and it happens by ordinance.
Where is Tier 1 and Tier 2 spelled out?
In city ordinance. It's a city ordinance that sets forth sort of where folks file.
It's adopted once every 2 years.
So what you're talking about with these regulations is to bring Tier 2 to have the same requirements as Tier 1.
In essence, that's correct. They would still, the departmental filing officer would still be responsible for sort of rounding them up, informing them of their obligations, that sort of thing. But the system would allow it to all basically be centralized, so people could search for it in one place. Yeah, that's correct.
And as I understand it, that even for Tier 2, they're public documents. The Form 700 that are filed by Tier 2 employees are public documents that some member of the public could go to that department and say, please provide me with a hard copy or a copy that I could review of the Form 700.
That's correct. And also, even with respect to, say, your Form 700s or the ones that are filed now, although online certain information, basically address information, is redacted, if someone were to come to our office and ask to look at it, we would give them that form in the unredacted form. So.
Any other questions or comments? Go ahead, Commissioner Andrew.
Mr. Minority, I wanted to, along the same lines, I wanted to hear a little bit more about what generally is redacted, and I think we'll probably lead into a fuller discussion on that, and if there was a rationale around what is most commonly redacted. And then I wanted to hear, it seems like there was also a determination on, for those who were either Tier 1 or Tier 2, some had ethics trainings and others did not, and I wanted to find out what, in terms of the imbalance there, what was the rationale behind that, and why it wouldn't have just been more sweeping for everyone to have ethics training around that.
Sure. Well, in terms of redaction, essentially we currently redact what is proposed, which would be phone number information, email address information, address information other than on real property interests, where you kind of have to know where it is to appreciate it. And then also the names of sources of rental income. So the idea being that if somebody rents from a public official, that person doesn't necessarily want doesn't know, has no expectation that their name is going to be on some Form 700. Again, all this information, if you request it, we will give it to you fully. It just isn't something you can search online. And so those are the default sort of redactions. The FPPC also, they do this similarly. They have some Form 700s, and they do redact address information, phone number information as well. They don't go as far as the sources of income, rental income, but it is address information, telephone number, and email. That's right.
And then around the ethics training.
So the ethics, do you want to?
The ethics training is required by the state, and the state mandate for mandatory training is essentially for department heads, members of boards and commissions, and elected officials.
Right. Can I?
So in the proposed, does it contemplate that then that it would be a recommendation that for those who would essentially be moving from Tier 2 to Tier 1 have an ethics training that they would be going through?
No.
So I can sort of respond a little bit more also to the training question. So as Director St. Croix mentioned, for certain city officials, they are required under state law to undergo ethics training. I believe what Ms. Ryan was referring to is to a lot of people who are not at that top level of the org chart. A lot of them are not required under state law to have an ethics training. I will say, as a practical matter, that my office and certainly the Ethics Commission, we certainly around the Form 700 deadline get inundated with questions, and we're happy to answer those questions. That's what we're here for. And I know I personally, and I'm sure my colleagues in the Ethics Commission, we are always happy to meet with any group of individuals or employees who wish to talk about any ethics issue. I get asked to do that not infrequently. I'm sure you guys do too. But in terms of a formal training process, that's not something explicitly mentioned in the regulation, but certainly something that we could work on.
The other thing, just to follow up, is that staff, even though it's not in a regulation, certainly the reason we had proposed this for consideration now is to ramp up sort of our outreach efforts. So we were talking with the filing officers, getting out there, telling people about the online filing, because the filing really would be triggered April 1st of next year. But we wanted to start in August to start with this outreach effort. I mean, it'll still be possible. It'll just be a little more condensed if we do it later in the year. But
my only follow-up on that is more just a comment, which sounds like it falls more in, at least in terms of staff and Pat's shop, which is to make sure that if we're going to hold folks, if we're going to be truly transparent and then hold folks accountable to it, that the training and education would be needed and available for folks so that they wouldn't find themselves running afoul of any requirement.
But I take it if we're talking about 3,000 employees, the expansion of ethics training would be a tremendous burden on the staff, wouldn't it?
Well, I mean, I think the thing to be clear about now is that all of these employees are filing, and they are obligated to file. The change that we are proposing, obviously, is that they would do it electronically.
Right.
And certainly as part of that process, as Andrew said, we are happy, and Pat, we've talked about the outreach efforts, and happy to talk to people and help them to the greatest extent possible. We do rely on the filing officers to a certain extent, and that's why they are the filing officers, because they're the ones that sort of do the talking, but a lot of times directly to the filers. But certainly we have thought of a calendar in terms of that outreach effort and how we could be most effective.
I promise. My last follow-up to my follow-up, which is, and I may have misheard during public comment, it felt like there could potentially be an argument, I was playing devil's advocate here, for those who may not be fully knowledgeable of their responsibilities in terms of filing, how they, in their defense, would say that they did not receive or the proper training or proper training was not available to them. So I, in essence, was kind of doing a roundabout and see if we could somehow address that and cut that off quickly. But I know there's more discussion to be had.
Yeah, thank you. Thank you.
Commissioner Herr.
If we decide to have automatic redaction for city employees, if we decide to require it being posted and have automatic redaction of the information you've identified, is there a mechanism by which someone who wants the information and can provide a compelling reason for it has a basis or a remedy for getting that information?
Certainly, and just to be clear, so the redaction would occur on anything that is posted online. But if somebody were to come to our office and to say, I want the unredacted version, that version would be given to them, completely unredacted.
Okay, so then if for example, the employee whose information was redacted online but whose information was requested in person determines or has a belief that that purpose was for harassment or suffers harassment as a result, then what happens? What is the employee remedy?
So there is another procedure that we put in there, which is that to the extent somebody does not want their Form 700 posted or wants it taken down at a later date, they can submit a request to the executive director and would have to identify compelling reasons.
So I understand that
Okay.
if it's posted online, but that wouldn't be necessary if we had this auto redaction, right? I mean, I thought that was in the instance where things are not redacted and we require compelling reasons to redact.
Well, I think it was contemplated that it would be both. I mean, certainly you could choose one or the other if you wanted to. But so for instance, somebody has to list the name of the employer of his or her spouse, and somebody's worried that a person who is upset with them is going to go to his or her spouse's work, and and it's not a huge company, but it's a law firm or something like that where it's easy to access that information. Maybe somebody owns some property and they're worried that their property has been defaced in the past, and they're worried, and it's, I don't know, like a store that the name is readily identifiable. The names would not be redacted per the normal process, but if somebody said, hey, look, I'm really worried, I'm getting these calls, they're saying they're going to do all this stuff to my business or whatever it is, we would then, if it's compelling, we would, the waiver could be requested, or the request could be granted. That then granting would have to be reported to the commission.
That person, though, after having it redacted online, could just go and get the paper copy fully unredacted?
That's true. That's true. I think the concept is that somebody sitting at home, I mean, it's degree. It's a matter of degree in terms of people searching that information out. You're correct that harasser could show up, request that information, and we would have to give it to them. The difference is we would just not post it online so that they could just do it at home or where they work.
But if they came to you, well, putting aside the Ethics Commission where they're being filed, but where they're presently being filed with the department head, the Tier 2 people, and somebody comes to the department head and said, I want to see the Form 700 filed by John Doe. He's got to produce it, doesn't he?
That's correct. Yeah.
And can he redact any part of it?
No.
So that if does the employee get advised that somebody's asked to see it?
There's no formal requirement. I mean, they may be told, but.
And there isn't on the Ethics Commission either. They came to want to get a copy.
That's correct.
Okay. I'll take public comment on this subject.
Patrick Menetshaw. I see Ms. Ryan's comments are once again amusing me. She claims two issues: a lack of training for the Tier 2 employees and its sensitivity to their privacy. Because they already file at the department level, members of the public can place records requests to obtain them, which are typically provided as electronic PDF file attachments, Ryan's concern about privacy is totally moot. As to her concern about lack of ethics training, that's nonsense. In fact, requiring the Tier 2 designated filers to only file Form 700s electronically doesn't go far enough. The Tier 2 designated filer should be required to take the biannual ethics training and the annual Sunshine training. Requiring both may well reduce both Sunshine complaints and the number of retaliatory wrongful terminations. They need to be trained. They can do the training in the comfort of their offices online, like the department heads do. Training is set up online, and the department heads take them and certify that they have taken the training in the comfort of their own offices. I'm aware that some city departments have intentionally not required contractors who are identified in the governing ordinance to submit Form 100s, despite the ordinance and the Ethics Commission's rules that the contractors who are identified by position in that ordinance are required to file them. Requiring only the Tier 2 filers to do this online, but not the contractors, also doesn't go far enough. You need to send this back and have the staff clean it up.
Thank you. Any other public comment?
Thank you, Commissioners. My name is Jean Karamati, and I'm an Airport Commission employee, and I've been a Form 700 filer for 33 years. I've also been the department's filing officer for that same amount of time. About 20 of the last 20 years, I have provided workshops for all of our new filers and any older filer whose status has changed. Maybe they've gotten married, maybe their job status has changed, and I've provided that information. I'd like to speak to you tonight. I also want to say that while I am an airport employee, I'm not speaking on behalf of the airport. I'm speaking as a filer and my experience in giving these workshops. And my big concern here tonight is, as Rebecca Ryan mentioned earlier, the issue of unintended consequences. And specifically regarding tenants of an employee. When a tenant signs a lease, that tenant has no idea that they will be signing away their right to privacy. And tenants, just like anyone else in the world, some tenants or many people have a reason for living maybe slightly under the radar. And those reasons could be they're intensely private people and they prefer it that way. Others may have escaped an abusive relationship. Others may be trying to avoid a stalker, or some may be recovering from such an experience. There is no expectation on the part of those tenants that their privacy is going to be invaded in that way. And it is not for me to question anyone's desire for privacy nor their right to have it. I would say simply that, I'm not going to read you all of my remarks, but I would simply say that there is a way to address this issue, and that is to simply have filers file their cover sheet that clearly identifies what schedules, if any, the filer has provided. And anyone going on your website can identify that and call me or any person identified on your website as the filing officer and then provide that information. But the point is that any tenant is now not, you can't Google that name and find where they live. If that information goes up on a website, that is exactly what will happen. You can Google my name and find out that I have filed, that I'm an employee of the City and County of San Francisco at the airport. And that's what I would be saying. That is the difference. That it's not, that it is no longer public. And one person is seeing it as opposed to the world.
Why wouldn't redaction take care of your problem?
redaction could take care of that problem. And if you're going to do that, that's fine. But if you just filed the form, then you also don't have the issue of the spouse's personal and private information being up on a website. And there's just some of those things that you can't control. Put the cover page up. You've got it. Thank you for your time.
Thank you.
Thank you. Hello again, Rebecca Ryan, Municipal Executives Association. I've already mentioned the training issue. I also meant to mention the fines issue and the issuing of fines, which really ratchets up the requirement and the importance of people getting the information they need to do it correctly. But I want to talk for a moment about the list of employees that are now designated filers. If you go to the government code section online, you can see department by department who these designated filers are. And I can tell you unequivocally that there is no analysis or rhyme or reason for the current listing of designated filers. In some cases, it simply says manager 1 through 7. In some cases, I found an intern, a receptionist, a librarian. So I ask us to go back to the intent of Form 700 filing. And at least from my perspective, if we're talking about expanding access to that information, we need to have a conversation about who appropriate filers are, how they're identified by the department, and what is the criteria that requires someone to be a filer. I think the thing we all understand, and the language in the ordinance is very clear about who are required filers. I think people understand when they become department heads or elected or appointed officials that the screen that's going to be put over them in terms of transparency is elevated. I don't believe that many of the people who would be impacted by this particular change, at least as the listings are currently structured and they're simply submitted by the departments, I don't believe those people have any idea that they could be subject to this level of scrutiny. And frankly, I don't believe there's any legitimate business reason for them to be scrutinized in this way. So it's a complicated issue, but it requires also some analysis and objectivity at the departmental level about who exactly are appropriate designated filers, regardless of where they're going to file. Thank you.
May I ask you a question? That's a concern I have, is that how is the decision made who files a Form 700? Because the purpose of a Form 700 is to advise the public so that the public can find out if there are any conflicts, if there are those kinds of transparency. Well, once a department says manager level 1 or manager level 2 must file one, it's difficult for me to understand how we can then say, but they don't have the same requirements of somebody else filing the 700. I agree with you. Maybe what really needs to be looked at is, are the appropriate people being required? Because those of us who have filed them know they're very intrusive. And I agree with you that many mid-level employees, maybe there's no reason why that they need that because you aren't concerned on the conflict issues.
Right. I thought, my understanding, please correct me if I'm wrong, subject matter experts, I thought the nexus was about potential influence that intersected with conflict, right? So if I had the ability to impact something that I was somehow conflicted on. So, for example, unless for a receptionist, for example, it's that I might not answer the phone call and because I don't like the person, because they're my neighbor or whatever. I just don't understand in some of these cases what possible reason there could be. And the thing about any classification of people in the city is that they do all kinds of different things, many of which may have none of that sort of policy or decision-making authority. And I think that's part of the problem here. The departments probably err on the side of some departments may err on the side of over-listing to avoid missing something. And it didn't really come to anyone's attention, I don't think, until you talk about something that expands access as dramatically as this does. Thank you.
Thank you.
Good evening, Commissioners. My name is Alex Tonneson. I'm a representative with IFPT Local 21. We represent over 4,000 employees at the City and County of San Francisco, many of which are part of this group of 3,200 Tier 2 filers. And we wholeheartedly support Rebecca Ryan and MEA's concerns about the problems that have come up because of this. I want to highlight one thing as an example. We represent housing inspectors at the City and County of San Francisco. It's an important job. We understand why someone like that might have to file a Form 700 in case they were told to inspect one of their own properties, for example. That obviously is a conflict of interest. However, it also, when information like this comes up online, it's so easily accessible, the potential of having someone retaliate against that inspector for doing an inspection and then essentially telling someone in the public, no, you have to fix something, you have to spend money, telling them, giving them an answer they don't like, and then having that person in the public easily be able to Google that inspector's name, find information, and then also, because of the lack of training, there's the potential that that inspector could get disciplined in a real way by the city for not having filled out their form properly. I mean, you imagine the cascading effects that this could have for our members, and we have real concerns around that. We look forward to continued discussion about this, but we think that this really needs to be vetted properly. We have questions about the list in terms of who's actually on that list, but we definitely support the process, and our members already fill this form out. The main issue is that once this goes out of the bag in the way that it has, where the public, anyone from the public can easily get access to that information, it really causes lots of concerns for our members about their privacy, their spouse's privacy, and the potential impacts on their livelihoods. A lot of these folks, when they signed up to do work in the city, they were not told, you're going to have to fill out a Form 700 when you start working here, right? That was not part of a condition of employment. And now they're being told that your information, your private information, is going to be online for anyone in the public to find. So, the important thing is to continue the discussion, and we are definitely open to that, but I think that you've heard a lot of our concerns, and we think that a meet and confer with the city on this is completely appropriate, and we look forward to having that meeting.
Thank you.
Good evening, Commissioners. Charlie Marsteller for the record, and I'm representing myself tonight and not Common Cause, an organization I once represented, but I did want to revisit some previous history. The Commission had a conflict which they investigated and actually fined the individual something like $15,000. That person asked for a waiver of the fine based on the fact that they were not able to pay it, and they demonstrated to the Commission's satisfaction that that was the case, and the fine was largely waived, if not entirely waived. I got wind that this person was an employee of the state, and so I went off looking for any SEI evidence for this individual, and I would encourage you sometime for fun to go looking for a state employee when you don't know exactly where they may be, or if they've even filed an SEI. So it was pretty time-consuming, but I eventually did track down a document, and we found evidence that, and I brought that to the Commission, that that individual was in fact negotiating the purchase of 2 homes at that very instant in which they were pleading poverty to the Commission. There was no remedy for the Commission except that fact. So for the people that are here tonight, I wanted to recount this story about how valuable an SEI is and how accessibility of that information is also exceedingly important in a timely way. So I thought I'd give you that story. It's an old one, and I'm sure we don't have this problem anymore, but you never know. I also wanted to thank everybody for being here tonight. I know it took a special effort to impanel all 5 of you on this night, so thank you for coming.
Thank you.
Good evening, Commissioners. My name is Mark Solomon. I live in the North Mission District. I'm a software engineer here in the city, and I can tell you that it is technologically possible to insulate online data sources from being indexed and served up by Google. There would be no problem to go ahead and take this stuff and make sure it was behind a don't index wall. The important part here is to make sure that the people who are really closest to the elected officials who do have the major conflicts of interest, basically the management of the city, is held accountable and transparent for their business dealings. I've seen through my advocacy here that, the management of the city is often, eager to please those who are actually exposed to more major ethical controls. I think we need to make sure that there's transparency that makes any conflict possible there. I like it when I see the union for the managers. That's always a real fun thing to watch here in the city. If there's a possibility that certain people might have real hardships, then establish a hardship process where people can appeal and say, I've got this, outstanding issue, and go ahead and, insulate my records from easy display. But people can come now and go ahead and get these records, get them in PDF file, and take them and index them pretty trivially if they wanted to. I don't think there's that much of a problem. But we do know that corruption here is pretty big in the city. We've seen the polling results. I think that you all need to go ahead and, take the union's interests into account, but the interests you represent here are the people of San Francisco first. We need to know what our government's doing, and this process could lead us that way. Thank you.
Chair Rennie, members of the Commission, I'm Larry Bush here for Friends of Ethics. Just a number of fast points, I hope fast. I certainly think there are circumstances in which you want to redact information on a filer. For example, let's say you have a filer who's living at a battered women's shelter. We don't make public even the addresses of where those shelters are. And certainly it's possible that somebody could be a city employee and be a battered woman, or someone who could have a restraining order, and you wouldn't want that information exposed in any way whatsoever. So the point is, when you talk about having redactions and an exemption, you need to spell out with some clarity what it is that are the basis for that, so that it doesn't become arbitrary or subject to the whim of any one person. So that's one thing. Second thing is, in terms of training, I was a Form 700 filer in the city, and I was a federal employee who had to file federal forms. All of those are done by training online, as has been mentioned. There's a little quiz that you take and you go through it. It doesn't answer everything, so if you have a whole lot of holdings at Wells Fargo Investments, do you have to list every one of them, or you just say Wells Fargo Investment? All those kinds of questions don't readily pop to mind, but that kind of training does not have to take a lot of staff time, and because this is a state form, there's no reason why ethics cannot move forward in coordination with other agencies across the state to develop a protocol and a training that people could access in their homes or at their offices, and then have a group meeting otherwise. We currently have a case where people have to file these forms under penalty of perjury, but to my knowledge, no one has ever been prosecuted for perjury, even though they've signed statements which they knew were not true. We've had people that came before this very commission in the past year who filed without disclosing that they had a conflict of interest and were providing funding from their office to an agency that in turn funded them. The commission never knew it because those things were never filed at this commission. They were filed at the department level. Earlier, we had the situation where people were not required to file, such as aides to supervisors. That's been changed as a result of a civil grand jury recommendation. But we did have an aide to a supervisor who accepted free cruises to the Mexican Riviera and then arranged for the cruise sponsor to meet with Rec and Park to try and get a waiver of all our rules for renting our property. So there are things where you really do have a significant and serious reason for wanting information. I suggest that you do send it back, and when you send it back, do a robust outreach to include groups like Sunshine Task Force and those who are transparency oriented to see what they have to say, not just filing officers.
Thank
you.
I'm Bob Plantold, and to be specific, I do support the expansion of a requirement that everything be filed with and through ethics. There's been a lack of concreteness here tonight. There's been a lot of abstractions. So I'm going to talk of experience I've had. We've already heard trainings can be online. A dozen years ago, ethics actually filmed trainings that were done in Herbst Auditorium. It's probably out of date now, but the point is it need not be a burdensome requirement of city attorney staff, ethics staff, or department staff. In fact, the state training is a specific requirement. You've got to go through this material and spend X amount of hours. I already knew a lot of it. I went through it, and they said, you flunked because I turned in my time before the X hours was complete. There is a requirement the state has of X hours, and you got to pass. It's simple. The city can amplify that or specify its own training. So that's a red herring, that it's going to be burdensome on staff. But let's look at the specifics. There are departments that have people who score or evaluate proposals and requests for grants. You really need to understand who those people are. They may not make the final decision. That may be a department head. It may be a commission. But the people who generate those scores, generate the analyses, are the ones who, in effect, make the decision maker tilt one way or the other. And if you don't know who they are, you don't know maybe their spouse is part of a company that's bidding or has some other problem or issue or bit of information that can be relevant. So people at that level, really, it's important to understand how much they influence the decision making. When you hear from ethics staff that anybody can go to a department, again, be real, be concrete. How would a person know that? But even if they said that from ethics, you can go there. How many are going to take the trek out to the airport? And then where do you find where the airport offices are and who it is? That's a lot of extra labor to go through. The PUC has multiple, if you will, departments within it. Some stuff could be filed way up Hetchy Hetchy or at Moccasin or any number of places. You don't want to have people go all over the place. A common database makes it easy to track what's going on within a department at the commission or executive director and at the level that actually influences or sets up the analyses. It's worth having consistent filing with you folks. Maybe you want to let departments do it too, but you folks need to be the central repository.
Thank you. Any other public comment? Any of the commissioners want to, as Mr. Minardi said, he was sort of looking to us to see whether or not we had some concrete comments on the proposed regulations and whether we think it's a good way to go, bad way to go, or whatever comments.
Well, I have a question. I want to go back to the point raised by Ms. Ryan, I think. How do we determine with any consistency who the second-tier, so-called second-tier employees are that are subject to this filing? Who determines that?
Jack briefly alluded to this already, but I'm sorry, Director St. Croix. So every 2 years, so every even-numbered year, I work with the clerk of the board's office, and we send out notices to every city department. We send out a notice to each department head or his or her designee, asking them to update, add, subtract, amend their section of the conflict of interest code, which is the code that designates all these tier 2 employees, as we're referring to them. And it's really up to each department head to identify the appropriate individuals. There is a legal standard that applies. They need to be a significant decision maker of some sort. They don't need to be the final one, but they need to have some influence on the process. But necessarily, it's somewhat of a gray standard. It's very hard to come up with a bright line for who should or should not file a Form 700. And we've always felt, speaking on behalf of my office and the clerk's office, is really the department head is best placed to make that kind of call. It's very difficult from the outside to look into each department's operations, especially since you're just dealing with job titles, who should be filing who not and who should not be. So it's really, really the department head's call.
And yet, from what I heard, there have been some questionable individuals or job titles. I mean, we certainly don't need interns to be filing these forms. So I question the consistency of the kinds of jobs that are being given to the Ethics Commission to ask for this kind of filing. And I'd like to see some process where there would be much greater consistency in understanding who really has any kind of influence that we should be concerned about. And I don't know, we do audits of other kinds, and maybe at some point there could be a process, not wanting to burden our staff, but some kind of process from time to time to audit, different departments as to the employees that have filed Form 700s and whether or not they're really necessary. Would that, Jack, or Jesse, can you comment on that? I mean, would that be like a really burdensome project for staff?
I'm not sure. It's an interesting idea. I mean, as Andrew said, one of the things is that we are relying on the department heads and their sort of understanding of what their staff does, how it works. Again, an intern, I think sort of most people would say, how can an intern be making decisions or participating in those decisions? Beyond that, on a sort of department-by-department basis, it's certainly something we could do, but it would probably take a decent amount of ramp-up in terms of understanding what everybody does, all the classifications. I mean, certainly, Ms. Ryan, we might look to other folks for help, particularly the department heads, I guess, but there would be sort of a ramp-up in understanding the department, understanding the duties, and that sort of thing. It's not much of an answer, I'm sorry, but it's possible, but it may be a decent amount of work. Yeah.
Well, something to think about.
Yes.
And I would agree with some of the other comments about, I think that there's still more process and work and detail to be worked out, and certainly meetings to meet with some of the unions and to get that interaction so that we really do this in a way that works for everybody.
Certainly, and one of the things that the Commission can consider is, both the substance of the proposal, as we put it there, the process for requesting in compelling circumstances things to be taken down. I mean, there could be a decision as to how the process unfolds, whether we go forward with it for this year or we wait until folks have kind of addressed this issue of who's filing, that sort of thing.
I also have a question for our IT manager about being able to protect information, redacted information, or the privacy of, the gentleman that spoke about that there are systems where we can make sure that certain individuals, their information is protected.
Even if you're protecting against Google, our site is going to be one step away from that. So, if the user comes to our site, they'll be able to run a search across all of the filings. So maybe they're not using Google, but they're using our site. I'm not sure if there is a one step removed, but it's still going to be very accessible.
Okay.
Mr. Chair, I'm a little more on the side of the fact that we're talking about a lot of abstract, and it's really hard to nail down the practicality of this, because when I think of the city departments And, the Mayor's Office of Economic and Workforce Development is, $20, $22, $25 million. And then you have a Department of Public Health that is upwards of $2 billion and has 2 hospitals and has, hundreds and hundreds, if not, I don't know how many staff. It's hard to figure out how you could come up with something that would just uniformly apply. So for me, and I'll just say that I am approaching this in a very fundamental, rudimentary way, I would at least need to see a document from the department heads on their procedures, on their rationale for what they use, because obviously DPH is not going to be using the same rationale as OEWD or Department of Human Resources or whatever it may happen to be. I would at least like to see from the department heads or their designee how they internally contemplate that and then ultimately come up with some kind of policy or practice that creates Tier 1 and Tier 2 individuals. During public comment, it was also mentioned that there are some decision makers who are through a RFP process, procurement process that truly could have some impact, and that is true. And as a community member, I've been a part of those. And sometimes they're high up, and sometimes they're just program folks who are deeply embedded within the department and are not decision makers on any particular day, except for that that day that they need to make a decision or a recommendation on an RFP that's out there. So, again, there's just even an inconsistency within the departments when you talk about procurement and RFPs.
Commissioner Herr?
I share the concerns of my fellow commissioners. A couple of things, though. One, that this problem already exists, right? They are filing Form 700s, and it is inconsistently applied. So that's a problem that exists. And frankly, I think if they're going online, managers will look more carefully at it, and we will have more education about it, and people will be a little more selective in making sure interns who have no decision-making power are not included on the list. So I think in some ways the problem may solve itself. And there will always be some inconsistency, because if you're leaving it to department heads to make the decision, and I agree with the rationale. It is very difficult for people outside to determine exactly who the right people are, and we do have to give some discretion. And I'm okay with having some inconsistency. But I think the benefit to the public of, once we work this out, having these online and accessible is going to be big. I think it is. It's useful as long as we have the redactions that are proposed by staff, because I have not heard any compelling reason why we need things like phone numbers and addresses of tenants and that kind of thing. And so if we redact that, if we work out the issues with the unions, I think we should go forward with it.
I'm curious that the letter that went out from one of the unions or a couple of the unions talked about this being part of the bargaining agreement. Now, what are they referring to? Is there some agreement between the unions and the employees in a given department that they don't file Form 700s? What brings out, what is the position that you've got to meet and confer with the unions?
Yeah, so under state law, and I'm certainly not an expert in this, so I'll try to give the broad outlines. Under state law, there are requirements that when a public employer is changing the terms or conditions of public employees' employment, that there is a requirement to meet and confer with the unions about the proposed change, regulation, change in policy, what have you.
But what is the change?
So the change would be exactly what we've been talking about. Instead of having all these Form 700s submitted in probably hard copy to filing officers, having these Form 700s be posted on a website. That is the change. As we've all discussed, the documents are already public. They already require some disclosure of personal financial information. So those things are not changing by any means. It's just a question about how you could access that information going forward. And so is that change they wish to discuss further?
And if the department agreed with whatever union it was that's covering its employees that we won't put them online, regardless of what we say, that would be binding, right?
I think it's just I mean, we certainly don't know what's going to happen, but I think it's just an obligation to at least have a good faith discussion about the issues. And I don't think anyone's looking at this in a way that, you know, the Ethics Commission would be overruled one way or the other. But certainly, since it is our proposal, I think staff is certainly willing to have that discussion with all of the affected unions.
Because I guess where I come from in a way is if we think there's a need for a filing of Form 700, I don't know why there should be a Tier 1 and Tier 2. Because the purpose of the 700 is to publicly disclose information which the public would have a right to know to see whether the specific employee has a conflict. And if the determination is made that he or she doesn't have decision-making power, then I don't think he ought to be filing the Form 700s. I think that's a burden that you put on them that shouldn't be there. But if you say you've got to file a Form 700, you've made a decision that that individual is a decision maker. And therefore, why should it be treated differently than it's treated for any other filing of 700?
I think that's what underlines this proposal, and is to get it easily accessible to people, certainly.
But I share the view that it may be that a lot of people are being required to file this Form 700 that shouldn't be. And they have a right not to have to disclose that information. But if a decision is made that they're in a position where they could influence a decision of the city, then I don't know why theirs shouldn't be online when everybody else's is online. With the redaction, and I don't have problems with the redacting certain information from what's on the online filing. All right, any other comments before we move to the next item? Item number 4 is a discussion and possible action on Commissioner Keane's proposal to place on the November 3, 2015 ballot a measure regulating expenditure lobbyists. And I guess either the staff or the city attorney want to comment on, or Commissioner Keane?
I do, yes.
And I want to thank you for your work on this. Regardless of how it comes out, it's, I think, a very well thought out proposal.
Thank you, Mr. Chair. And just as background for everyone to recall, a couple of months ago, Chair Rennie asked me to serve as an ad hoc committee of one in order to look over criticisms and proposals relating to Prop J and other changes that had been instituted upon this commission relating to reporting and other types of requirements, with a view towards perhaps coming back to the commission, as had been very strongly recommended by the Civil Grand Jury, Friends of Ethics, other people over the years, with some proposed ballot measures that might take into account some of the changes that have been made, go back and perhaps fashion new ones that might meet the criticisms that full transparency regarding lobbying and lobbyists in our government, and our governmental structure in the city simply was not there. And it was a rather cosmetic type of oversight of lobbyists that we had when we shrunk the definition of lobbyist back to just a contact lobbyist, someone who does not have to register as a lobbyist no matter what sort of efforts or money that they've paid in order to affect city policy, statutes, or elections of people, unless they actually had some sort of actual physical contact with someone whom they were trying to influence. After discussions with Chair Rennie, I told him it was my recommendation that a full rewrite of a number of things relating to Proposition J for the November ballot this year was simply too ambitious. It couldn't be done. And one of the things that could be done, which was a more modest proposal, a more modest change going forward, was to expand the definition of lobbyists in one respect to meet what had been the definition of lobbyists. There had been 3 definitions for lobbyists: contact lobbyists, expenditure lobbyists, and another form of lobbyist. And that was to expand the definition of lobbyists and to make expenditure lobbyists required to register as lobbyists with our commission and file reports. With that in mind, at our last meeting, I made that recommendation that I be empowered, again, as an ad hoc committee of one, to go forward and write such a proposal for the ballot. The commission voted 4-1 in favor of my doing that. I went forward and spent a good amount of time with Andrew Chen and Jesse Minardi, whom I want to compliment considerably because their efforts in regard to the writing of this and putting it in the particular form for the ballot have been really excellent. They put in a lot of work on it. We've had several meetings, both here and at other places. We had an interested persons meeting, which Mr. Minardi put together, and that I attended. A number of members of the public came. And I think, as Mr. Minardi's report shows, they expressed overwhelming support for the recommendation that this expenditure lobbyist requirement be added to the city laws and that expenditure lobbyists be required to register with our commission when they engage in expenditure lobbying. One of the big changes that I had made from my original writing that was put before this group, I made at the suggestion of Commissioner Herr, who said that, in his opinion, there should be some provision on there for the Board of Supervisors to change it if they feel it's appropriate. There was a fair amount of opposition to that, but we went through and put that on there in regard to the Board of Supervisors could change it in the future so that something isn't locked into stone. They have to change it so that it doesn't change the spirit of it, and it's in accordance with the other rules relating to the board, to the commission. And if they change it, they will not change it in a way that is going to lessen any kind of reporting, because the main thing we want is reporting. So, in regard to the question itself, expenditure lobby, what is an expenditure lobbyist? Well, an expenditure lobbyist is someone who is going to spend all sorts of money to go ahead and affect a city proposal or a city piece of legislation or a city election, but not having any direct contact. For example, we've had situations where Uber and Airbnb have spent large amounts of money in regard to mobilizing people to come down to City Hall for various types of things that were on before the Board of Supervisors and other matters. Spent fairly large expenditures in terms of training for these people, meetings and lobbyists, lobbying and cheerleader efforts, and transporting them. Nowhere is it in regard to how those measures are being affected that these high-paying, pay-to-play characters were involved in spending a great deal of money influencing city policy. I think, and in terms of the interested persons meeting, colleagues, it was clear that everyone agreed that in terms of the people of San Francisco, they should know what sort of money is being spent and who's spending it in regard to measures that are before our city government. And we should not have this kind of hidden pay to play. It's not a question of outlawing anything. We can't outlaw it. They can still do it. Unfortunately, because of decisions like Citizens United, anybody, pretty much government can be corrupted by money very easily, and it is. We live in a time of extremely corrupt government in terms of people and entities and high pay-to-play characters in the background spending all sorts of money to determine basic policy within our system, and people don't know that any of this is going on because there are no disclosures. All this does is this makes transparent to the public so the public can see when a particular matter is on before them who's behind it and what's being done, rather than it being clothed in some sort of rather deceptive type of good citizens in favor of apple pie and motherhood for so-and-so, which is the way it's clothed now. And behind the scenes, you've got all sorts of things that are not just questionable, they're corrupt, they're even dirty. And in regard to shining a light on those various things, this goes a little ways towards doing it. It is indeed a modest measure. We're putting it on the ballot, if my colleagues agree, and I think it's a salutary measure that should go on the ballot, and I ask my colleagues to vote for it.
Any other commissioners? I have a question about the language under the section 2.115 provisions called prohibitions. Where it talks about that no lobbyist shall make a gift to an officer of the city and county that has a market value of more than $25 except so-and-so, and the future employment, would an expenditure lobbyist, say Mr. X, be one of those who's prohibited from making contributions to a candidate and from the other things that a lobbyist is prohibited from doing?
Yes, in terms of where it says no lobbyists, as it is now, no contact lobbyists can do it. So this would be, I defer to Mr. Chen because this is on the language that's already in the statute. This isn't a change in the language. This is in the language that's in the statute itself. So in terms of the existing effect of it and how that would carry over, I'd defer to the city attorney on that.
Right. So just to clarify, so currently there is no prohibition on lobbyists making contributions, either contact lobbyists or as proposed expenditure lobbyists. Actually, they're just required to report such contributions.
How about the gift?
So the gift limit and future employment prohibitions, as currently presented in this measure, would apply to expenditure lobbyists as well as contact lobbyists. So the expenditure lobbyists would be subject to a gift limit in terms of what they could give to an officer of the city and county.
So that, for example, we know that we've had some of the big money interests that pay $450 or whatever it is, it's the maximum they're allowed to make a gift for travel. But if that individual is deemed to be an expenditure lobbyist, he or she would be unable to make those kinds of gifts.
Yeah, the gift to travel gets into a little odd universe of regulations. There are certain exceptions that could allow such gifts of travel, but I think your point is correct. The fundamental point that is a new category of lobbyists, expenditure lobbyists, would be subject to a gift limit with respect to what they get to give to certain officers.
Okay.
Commissioner First of all, I do want to thank Commissioner Keane, the city attorney, and the staff. I think I can tell a lot of work went in, especially between the last draft and this draft. I think it's much improved. I appreciate putting in the amendment or repeal section. I think that's important to making sure that, if we enact this, that it can be fixed if needed. I do have some questions and some proposed changes because I think there are some things that are still unclear. In Section 2.103, my hope was that this would kind of reflect what we do in CFRO, that we need a supermajority of the board to fix this if there's a problem, and four-fifths of the commission, making sure that it's consistent with the purposes of the chapter, the appropriate review, et cetera. There does appear to be some additional language that's not in CFRO, and I'm not sure why we need it. I'm a little concerned it's overly restrictive, and that's in subsection A. What's in CFRO, I believe, is the amendment furthers the purposes of this chapter. But everything else, I think, is an addition that would be unique to this particular provision, and I don't know why we need it. I think if the amendment furthers the purpose of the chapter, if it's done by four-fifths of the commission and a supermajority of the board, and these other requirements are met, then the amendment should be allowed. I don't think we need a finding that the amendment, specific findings, specifics to substantiate the findings, and I don't really know what it means that the amendment does not result in reduced disclosure. I mean, I could imagine a world where you want different information disclosed, and we determine that's necessary, and I don't know whether that would be considered a reduction or not. So I worry it creates more problems than it solves.
If I can address that, and where that language comes from is a basic suspicion that members of the civil grand jury, Friends of Ethics, other people have had in regard to other changes that have been made by the board to the jurisdiction of this commission, and just have done it with sort of a boilerplate statement that it furthers the purpose of the act. And there is a viewpoint out there in regard to some of these other changes in history that that was just gratuitous language that was used, but what it really did is it restricted what had been the jurisdiction of this commission tremendously and cut down on a lot of very valuable areas of oversight and transparency. So the thought was that rather than members of the Board of Supervisors, a political body that are subject to the whims of many things, including pay-to-play and lobbyists, hopefully we're not, and we're not. Well, that's one of the beauties of this body, is that we would sort of hold their feet to the fire and say, you can amend this for the purposes, if you're amending it in conformity with the purpose of this act, but if you just cut the heart out of it, that's not what you're doing. What you're doing is you're emasculating it, and you're doing it disingenuously. So what this is an attempt to sort of keep the process a little bit more honest. We see that what this does is this adds levels of disclosure, that if people agree with the act, they agree that the levels of disclosure are good. So anything then that reduces the levels of disclosure, you're going to say, wait, why are you reducing the levels of disclosure? We want some findings in regard to it. Rather than just having the board, again, subject to lobbyists, subject to all of the things that go back to the pay-to-play thing that we're trying to sort of hold the tide against, it's an incentive to make sure that they just don't wipe out the heart of what we're doing and say, well, we're really complying with the spirit of the act, which says nothing, really.
So two comments in response, and I appreciate the explanation. The first would be that I agree with you. The board, obviously a political body, and we want protection from it being gutted in a political way. But this would also require that 4/5 of the commission approve it, any change. So I think there is some protection in the event, from the board. The other point is that the way I read this, it would prohibit under any circumstances an amendment if it results in, quote, reduced disclosure. Not that we would need more findings to reduce disclosure, but that that's just flat out prohibited. And so I really think we should strike everything that comes after that first clause in A. And otherwise, I think 2.103 is good and should be part of the proposal. I have some other questions and comments. Should I go through them, Chair Rennie, or what would be your preference?
Well, why don't we could I suppose there isn't a motion at the moment, so I guess why don't you go through your comments on it, and then when a motion is made, if you want to move to amend and see what we go with there.
Okay. My next questions have to do with the actual definition of expenditure lobbyist, which is on page 5 of our memo. And my first question has to do with the word indirectly in the third line. And I'll read starting from the beginning of that clause. Who makes payments totaling $2,500 or more in a calendar month to solicit, request, or urge, directly or indirectly, other persons to communicate directly with an officer of the city and county in order to influence local legislative or administrative action. I'm not sure what indirectly is meant to encompass there.
Well, I think that's part of the whole problem that we're trying to address, that you have these layers and these levels of essentially laundering of who's behind things that this is attempting to address. So in terms of doing something indirectly, if you have, for example, Airbnb getting one group to then influence another group to do something directly, it's being done indirectly. If anywhere along the chain of causation you have a particular entity or group or person who is doing these things in order to have the ultimate effect of what we're talking about, that's an expenditure lobbyist.
I see. Okay. So it's meant to modify. What we're trying to do is find people who are indirectly urging others to communicate with an officer or of the city and county. Yeah, not that there's ways to indirectly communicate.
Yeah, exactly. As it is now, it's almost like money laundering. You have a series of transactions or a series of levels of characters and individuals who at some point the strings are being pulled by some puppet master who is then affecting policies of the city and county of San Francisco, and whoever that person is, no matter how many indirect layers there are, that person is an expenditure lobbyist, and the ones in between as well.
I understand. Based on that, if I could propose, one change I would propose is where we say who makes payments totaling $2,500, I might add the directly or indirectly right after who, so that we know we're talking about the person who's paying. Because the way I first read it, I thought it was trying to suggest that there are some indirect ways to communicate with an officer of the city and county. And I think based on what Commissioner Keane has said, the purpose is really to make sure the person paying is not directly or indirectly affecting the action.
Chair Rennie, in order to expedite things, I'd accept that as a friendly amendment if we get to it.
Another question relating to this section. The examples of what we are going after, for example, on page 2, where we say we want to prevent or just have disclosure of people who are urging others to attend legislative hearings, to speak on their behalf, providing transportation to such meetings, or by using advertising outlets to ask others to call city officials. I understand that. I get that. I think it's an important thing we're trying to address. But then the examples we use in expenditure lobbyist, to me, appear more opaque and vague. Things like public relations, media relations, advertising, outreach, research. To me, I think that creates a level of vagueness that is potentially harmful. For example, are you an expenditure lobbyist if you conduct a lot of research to determine whether or not you want to urge others to communicate with your local official? And are you an expenditure lobbyist on the day you spend $2,500 on the research, even if you haven't made any communication or indirectly or directly made a communication to encourage others to reach out to an elected official? I just think that's problematic. To me, that you wouldn't be an expenditure lobbyist at that point. But based on the text, I think you would be.
Oh yeah, I think if you have the resources of an Airbnb or an Uber, and you are commissioning a bunch of people to come up with the most effective way to influence city policy, to get a measure passed, to get someone elected, to engage in all sorts of research, perhaps opposition research, perhaps hit pieces, perhaps things relating to other people's backgrounds. That aspect of research, if it's geared towards whatever these efforts are that we're talking about here, research, investigation, reports, analysis, if they're geared towards the ultimate end of affecting whatever the institution, the passing of an ordinance, or whatever else that might be involved, that is an example of expenditure lobbyist. You're engaged in all sorts of activities, spending tons of money, and that's being done now. And it's behind the scenes, and ultimately something pops up for the public's radar, and what pops up for the public's radar, at best, is the head of a mole which says citizens for apple pie and good government, whereas underneath the surface, you've got this gigantic dinosaur that has been involved in creating this to begin with, in terms of spending money, mobilizing people, being involved in things that the public is simply not aware of. So that's what this is geared towards addressing, to getting down there under the surface and seeing what's going on in that rat hole.
So, well, I can appreciate that there are things beyond just the direct communication. I do think that there needs, and it sounds like you'd agree, Commissioner Keane, that there needs to be a nexus between the study or the report or the research and the communication or the efforts to encourage others to communicate directly with an officer of the city and county. So, and I'm curious to hear what the public thinks, but I would propose some language that ties those activities to the communication so that there is some nexus between the two. Because I could imagine a situation where you do the research, or you do the research for some other purpose, and you later determine, hey, that research had different information that I now want to use to encourage others to communicate with the city and county. And at the time that research was done, it wouldn't really make that person an expenditure lobbyist. But at the later, when they decide to make the communication, perhaps it does. But if we don't tie them together, I worry that there are unintended consequences.
Commissioner.
I had more, but I'm.
No, go ahead.
Keep going.
Relatedly, in Section 2.110, and maybe the nexus could be made here, but it relates to my same concern, that I think the expenditure lobbyist should be required to disclose at the time that they are actually doing the urging of others to communicate with elected officials.
I'd accept that also as a friendly amendment, Mr. Chair.
I was a little bit confused with activity expenses. So if you look on page 14.
Excuse me, Commissioners. Could you back up to the last point? I just want to make sure I'm tracking all the amendments. So was there a change made to the text in 2.110?
I'm not sure what the best language is, but I would propose something after the word studies that ties those activities to actually communicating with an officer of the city and county.
I understood that point. But did you propose something else in 2.110, leaving aside the definition of expenditure lobbying? And I wasn't sure whether Commissioner Keane was considering a friendly amendment in that section. I just want to make sure I'm not losing anything.
Oh, I don't remember any language.
Yeah, I didn't propose language to 2.110A. I think if you fix it in the expenditure lobbyist definition, then it would solve itself. But I think it could be done in either place.
Okay, thank you.
With activity expenses, and I believe one of the other commissioners alluded to this before, but a couple things I don't quite follow.
What page are you on?
I'm sorry, page 14. So activity expenses for an expenditure lobbyist may not be inclusive enough. In other words, for a contact lobbyist, it makes sense that you have activity expenses that you have to note, and an activity expense is defined in part as a gift to a officer or aide within 3 months of a contact. But kind of, maybe not by definition, but certainly an expenditure lobbyist could be making such gifts without having any contacts because they're not a contact lobbyist. So to the extent that we're trying to encompass any sort of payment or gift that is made to a candidate or their immediate family or their aide, I'm not sure we're capturing that if we just use the definition of activity expenses that was previously used for contact lobbyists. Now,
I'm sorry.
When it comes to the actual elected person, it may not make a difference because I don't think you can make any gift totaling more than $25 anyway under different portions of the statute. But for those who are, the immediate family or the aide or others, there may be a loophole, an unintended loophole there.
Just one thing, though, Commissioner Herr, and that is that you'll recall that in our previous discussion, the question relating to gifts and having to do with contract lobbyists, that's already in the language. This amendment is a very discrete amendment which has to do with the category of expenditure lobbyists, establishing that category and setting up that category. It was not intended in any way to make any kind of changes to contact lobbyists. So your remarks just now in regard to, we don't quite capture that in regard to contact lobbyists. We're not dealing with contact lobbyists. So I'd be hesitant in regard to the scope of what we're doing, since we've said all along what we're doing is we're proposing something and amending something having to do with expenditure lobbyists. We're not touching anything having to do with contact lobbyists. Whatever's there is there. So now to make the jump and make some sort of change in contact lobbyists, I don't think it would be appropriate in terms of what our task has been.
I understand and agree completely, and I probably was not clear in my point, but I'm not trying to change the requirements of the contact lobbyists. I'm saying that if we use the term activity expenses for the expenditure lobbyists, which is the same term we use for contact lobbyists, it may be under-inclusive because the definition of an activity expense is related in part on how close in time one had contact with an elected or with the elected's aide. So that really doesn't apply for an expenditure lobbyist. So you may be excluding payments that you probably want to include, right? I mean, if I make if I'm an expenditure lobbyist and I make a gift to an aide and I never see that aide, you probably want to capture that in here, but it wouldn't be captured because they wouldn't have made that contact within 3 months. So I don't know how we want to address that, but that seemed to be a little.
I see Mr. Minority and Mr. Chen nodding their heads that they understand, and I understand as well your point, and I agree with your point. So.
Right. So we were actually just brainstorming over here. So I think there's a few different options with the activity expense point you raised, which is a very good point. So right now, as you mentioned, the activity expenses, well, an expenditure lobbyist basically would never report an activity expense because an expenditure lobbyist, by definition, is not making any direct contacts with an official. And since that's embedded in the definition of activity expense, we would be requiring the monthly reporting of something that's never going to happen.
Well,
so there's a few potential.
Let me stop you right there.
Yeah,
though.
sure.
So if I'm an expenditure lobbyist and I provide some benefit to a supervisor's aide,
yep.
Why isn't that an activity expense?
Because the activity expense right now only counts any offers of those services made within 3 months of a contact.
Oh, I see.
And an expenditure lobbyist doesn't make contacts. They indirectly lobby.
Okay.
So right now we're basically required the reporting of something that's not going to happen.
Right, but that's exactly the problem.
Right, exactly.
Yeah.
So I'm just saying I totally understand your point. I think it's a great point. So there's a few different options, I think. The first is that option one is you could decide not to require the reporting activity expenses. That's one option. Option two is we could have a specific definition of activity expense just for expenditure lobbyists. Option three is actually to change the definition of activity expense, which has this 3-month reference. In the second sentence of that definition, so page 4, lines 3 to 7 has this 3-month time limitation. We could actually remove that altogether as well, because activity expenses are reported on a monthly basis, both for contact lobbyists and for expenditure lobbyists under this proposal. So the 3-month reporting period actually doesn't, frankly, make that much sense either for contact lobbyists, because you would only be reporting activity expenses you made during that month anyway.
That sounds, all of those options sound okay to me. The one about the third that makes me hesitate is what Commissioner Keane said earlier, that we're not really here to amend the contact lobbyist provision, and I'm not sure we should do that given what we've noticed and the like.
Okay. So at least two options we come up, and maybe there's others. We're kind of coming with language on the fly here. Is again, the first is not requiring the reporting activity expenses for expenditure lobbyists, so we would remove that from the disclosure obligations. Or two, coming up with a different definition of activity expense for the purpose of expenditure lobbyists. And if you want to build in some time limitation, 1 month, 2 months, 3 months, what have you, we need to say what the starting point would be. 3 months from what?
Right.
And it could be things like 3 months from the date the payment is made that triggers expenditure lobbying, 3 months from the attempt to influence that actually occurs, 3 months from when the final decision is actually made, which is the subject of lobbying. It could be a whole variety of things, but we need some sort of trigger.
That makes sense to me. My last, and thank you for the indulgence. My last question had to do with employers who employ people to perform some of these actions, and I just didn't understand how it worked. So let's say you are a company who has an employee whose job is governmental relations, and that person makes $100,000 a year, and 10% of their time or 5% of their time is spent on city and county of San Francisco activities to encourage people to talk to or appear at meetings relating to the city and county. Is that employer an expenditure lobbyist, and how are the employers to know when and how their employees have made the employer an expenditure lobbyist?
I think some of this, such as that, if I'm not correct, Mr. Minority, we used other jurisdictions' definitions of expenditure lobbyists in order to arrive at a number of these things: Sacramento, Los Angeles, San Diego, other. And do we have guidance on Commissioner Herr's point in regard to the language that we used here from other jurisdictions, or how did we come up with that?
I don't think that we have guidance from the jurisdictions where we took this language from. There are jurisdictions that do recognize that employee time obviously can be used towards these types of efforts, and those are the state, for example, where they set a threshold. So to the extent the employee spends, I believe it's 10% or more of his or her time in a given month, that employee's time would be used, the compensation he or she receives for those particular efforts would be used in determining whether somebody triggers or not. But that's all via sort of regulation. So, it's something that, we could deal with, but it is, I think Commissioner Hart's right that it's not particularly called out here in the statutory language.
Would it be something that would be appropriate to be dealt with by regulation, and how other jurisdictions dealt? What I'm saying is, as we get more and more into the weeds of this stuff, we can find ourselves parsing things way down into areas that are not necessarily required in a drafting type situation. In terms of the other jurisdictions, from what in my discussions with Mr. Minority, Mr. Chen, and also the other people who've been involved in this, both on a statewide level and in terms of Los Angeles and Sacramento and the other places, there is a level of these concerns, these definitions, these activities that is just appropriate left to regulation. And I'm wondering whether or not the point you raise is one of those, and if as we get to those, we can express what our desires would be geared towards future regulations, because that's what every administrative body does at some point. They just say, we can't write 10 volumes of stuff. We got to leave some of it to regulate. We got to leave some of the weeds and the details to regulations. Would that be appropriate, Mr. Minority?
I mean, it has happened, so it certainly is something that it's up to you. It's up to you. I mean, there are obviously in listing out exemptions, for example, which is here in the statute. That's another thing that can be accomplished via regulation, but it's completely. It happens in other jurisdictions where, when you're getting into the weeds, like you say, that you do deal with that via regulation.
The reason I'm bringing that up is because, colleagues, this is the first time, in 13 years or so, we're attempting to put something on the ballot. Exactly. We are not full-time legislators who spend all our time drafting legislation. We're doing the best we can with what I think is an effort that is quite desirable, and that what many of the people who've appeared at our interested parties and the members of the civil grand jury and the Friends of Ethics say it's commendable that we're doing it. We could spend a lot of time. I'm not, in terms of legitimate stuff that's coming up, I'm fine with that, in terms of our dealing with it, amending it, tweaking it, and all that. But if it's a question of, again, getting so far down in the weeds that we can allow it to be left to the direction of our staff with regulations, I would say, just in the interest of the fact that we don't want to be here for 6 weeks, going into every little detail, in regard to some of the stuff, we may want to consider doing that. Again, not in terms of people who have deep concerns, we should definitely address them and we should change them as they come up. But I would just throw that out as something that we can be guided by.
Commissioner Andrews?
Yeah, Mr. Chair. Yeah, it's interesting we find ourselves at this point. Just at what we're discussing, this where a particular person for a for-profit could have a job title that is government relations and 10% of their time is spent in interfacing with government officials and affecting legislation or proposed legislation or some administrative outcome. We could leave it to regulation for that, to address that. And you and Commissioner Keane rightly brings up Airbnb and Uber, and I'm sure they have government relations folks where they spend probably 10% of their time doing just that. And in that 10% of the time, achieve exactly what they want to achieve. And may not, I mean, we're leaving it to regulation to take care of. If they spent 9% of that time, they may end up getting exactly what they want. And we haven't addressed any of it. So I just want to make sure that we address that. The double-edged sword to that is, and I wanted to just touch on base on the nonprofits who ultimately hold many contracts with the city. It's basically how much of the city's work, the county's work gets done is through contracting through nonprofits that ultimately have lots of conversation and engagement with city department heads and such. And I know that there are exemptions that are made in contact, and I believe under contact, but not under this, not under expenditure. So I wanted to hear a couple examples of nonprofits who would have an expenditure activity and why they wouldn't be exempt. Would the Coalition to End Inequality, Income Inequality, who has a series of town hall meetings and spends over a period of 2 or 3 months ordering pizza for interested persons who are directly and indirectly impacted by the income inequality in San Francisco. Play that one out for me, or a couple other examples I'd like to hear about nonprofits who would be falling under this particular proposed legislation, expenditure legislation.
I think they would definitely fall under this proposed legislation, and there's no real onus in regard to having them come under this regulation, because they are groups, no matter how salutary and desirable they may be, and how much we might all love them, they still are groups that are affecting policy and statutes and government in San Francisco. And I think the people of San Francisco should know whoever they may be. And there's no real harming them by them being. We're not saying we're putting you in a rogues gallery with Al Capone and a bunch of other characters. You're just part of a group that come under a category that are affecting city policy, city laws. The public should know about you, whether you are good government groups or groups that are suspect. And in order to get the public's knowledge of all of the groups, including the suspect groups, we have to go ahead and cast this net. So I think if I were involved with those particular nonprofit groups that you're talking about, and I saw this, I'd say that's fine. All right, no one's prohibiting me from doing something. I'm affecting what's happening to the people of San Francisco and the voters of San Francisco and the policy of the city and county of San Francisco, so they know I'm doing it. I'm not afraid of that. And I don't think any reputable nonprofit group is going to say, "Hey, wait a minute! You put me on this list. You're really doing something terrible to me." I don't see that coming forward.
Just to segue a bit from Commissioner Andrews' question and comments, just a segue from what Commissioner Andrews has said. I have a couple of concerns. One is, as you describe an expenditure lobbyist, I mean, aren't you really describing the process by which all citizens lobby government agencies and elected officials? I mean, it's in the nature of community organizing and political organizing during campaigns or any other time. And I question the need to regulate that. Yes, there may be some bad players out there. You keep referring to Airbnb and Uber. Fine, they're the current villains, and yes, we probably need to know what they're up to. But I also question, do we really not know? Really? I think the public is very well aware that there are players, nefarious or good players behind the scenes, pushing agendas. I mean, we're not stupid. The public in general is quite aware of this. I'm not convinced that more regulations are somehow going to change this scenario. People will always be trying to influence our elected officials. And in that, I mean, in terms of contact lobbyists, I mean, that's really I think a primary role, and those regulations certainly make sense. But you're talking about, what your example of, buying pizza, nonprofits. It's going to be an onus on nonprofits. I mean, nonprofits have training sessions, educational sessions. They recruit members of the community to then have them have this additional onus of having to report all of that on a regular basis. I have to question that. So I don't know. The other concern I have is, why does it need to be a ballot measure? Fine. I mean, we have regular people who come here and bring us their comments, and they're very wise comments, and I respect the vast majority of people who share their point of view. But, and they're, on top of every word and on top of all of these issues. But realistically, at least from where I sit, the vast majority of San Franciscans, voters or otherwise, they don't know what an expenditure lobbyist, and they're not going to read through all this stuff and vote on it. I mean, they'll see maybe the first couple of words, and fine, it either sounds good or it sounds bad. But they don't know what it involves, and it's just another layer of regulation that makes life very difficult for all of us involved, in one way or another. I think it actually is going to create an atmosphere where nonprofits who do want to influence, and probably for the right reasons, are going to really hold back, and perhaps it's going to be inhibited in participating in the political process, and that concerns me. Well,
this doesn't prohibit anybody from doing anything.
No, but it can inhibit people. That's what I would say.
Well, all it does is it says that if you are involved in affecting public policy in terms of ordinances that are enacted, people that are elected, and you do certain things that come to the point of expenditures in that behalf, the voters of the city and county of San Francisco, the people who are going to be voting on this, they're going to know that you're doing it. What's wrong with that? And to say that that's some sort of tremendous burden for us to have transparency and informed democracy, that's a tremendous burden. That's the first time I've heard transparency and informed democracy and informed voters and things being done towards making sure that we have informed voters and transparency as in a democracy being like, well, say that's burdensome. We don't want to. a little bit taken aback that you characterize it that way.
I'm not sure she characterized it that way, and I don't disagree with her. I mean, look, there's a balance between burden and what you're getting for the transparency. And I, certainly my view is if you want the right transparency, right? We don't want to create a system that's so burdensome that it's incredibly expensive and unwieldy and has unintended consequences on those who can't afford it. All in the name of transparency. I mean, I don't think that's the answer either. I do think there's a balance, and I reject the notion that transparency for everything is an ultimate good.
Well, I reject the notion that this very modest effort, which is done in Sacramento, it's done in Los Angeles, it's done in San Diego, it's done on a state level. It's done in terms of most of the major political jurisdictions in California, that somehow that's been shown to be terribly burdensome. And for us to go ahead and just follow that same line and opt for the kind of transparency that other jurisdictions have, this isn't any kind of radical measure that breaks out from that and imposes all sorts of terrible burdens on people. This is in line with things that are being done now in other jurisdictions that are seen as sensible ways for transparency. San Francisco stands out among these jurisdictions as something of an outlier that is somehow completely lacking in some of the most basic aspects of transparency, this one being one of them, and are saying, well, we really don't give a damn because people are going to find this stuff out. Maybe they are, maybe they're not. And if people are manipulated, well, that's okay. That's part of the game. That's I think that for us as an ethics commission to take that line, very unfortunate.
Well, if I might say, I do not think the activities of a nonprofit, Sierra Club or something like that, falls under expenditure lobbyists. What I think you're really after here is whether it's Airbnb or it's one of the high-tech billionaires who are paying people to try to influence government. And it's what the public has a right to know is who's behind. We hear the ads every day on, about Airbnb and how good it is for the economy and how it's helped. I don't know who's paying for them. They don't say these are paid for by Airbnb. And the public hears them, and part of them are individuals who say, I'm a school teacher, retired school teacher, and I'm a required social worker, and this has been such a good thing for me. Who's paying for them? They aren't doing that on their own.
Well, then it's an ad. It's clearly a commercial.
But who's paying for it?
Whoever they're talking about. I mean, that's pretty obvious.
But that's all this says.
But then it comes on and it says, this ad has been paid for by Mothers for Apple Pie and Healthy Children. That's what it'll say. It won't say Airbnb is paying to do this, or it's not going to do that. And that's the whole point. You have this complete hiding of transparency. It's not a question of, we're making transparency a burden. We're opening up transparency, and we're showing in some of the things like Chair Rennie has said, a whole system of really devious politicizing and advertising, and the actual powers that be and the money that's behind it is no way apparent and is actually being hidden. And the idea that somehow, that's okay.
Well, I'm not against transparency, Commissioner Keane, but I just feel that I need to voice those particular concerns.
I understand. We're going at it in a nice, robust way here, which is the way.
Shall we?
Wait, just to be clear, this does affect nonprofits, though, right?
As it lays it out here, it seems from page 1, which I couldn't understand why, so out of a contact that could easily lead to the same outcome in terms of some legislative movement or administrative movement, why we felt that nonprofits could be excluded there, and somehow not within an expenditure, this proposed legislation, not have that, because I do believe that how nonprofits do business is different than Airbnb and is different than Uber. That in the course of the work that they do daily, while they're working through the budget system and educating their constituents who are vulnerable San Franciscans and having these town halls, I'm struggling with them having to register as a lobby. And I will just say this, and this is arguably full disclosure, I work for a nonprofit, but I do know that there are a significant amount of grants that ultimately will ask you, are you an advocacy and lobbyist organization? And most health and human service organizations who are receiving any kind of funding, foundation funding, will mark no if they're not a policy and advocacy organization. But it sounds to me that under this proposed legislation, they would have to register as that, in which case they would need to make some kind of decision for themselves whether to continue to say that, or now because of this, now have to mark themselves as a lobbyist because they in San Francisco would have to be registered as an expenditure lobbyist. Within that activity, and I guess I've never really fully directly asked Commissioner Keane, the example that I gave, would you consider that an expenditure lobbyist? Well, the activity that they did and the expenditure that they had over their series of town halls to educate the community about their services around income inequality.
Well, let's go to our experts in regard to other jurisdictions and the way that this language has played out there.
Well, usually, and I have to say I can't remember all off the top of my head, but for instance, at the state level, there is no exemption for nonprofits. I don't believe in San Diego there's an exemption for nonprofits. That I'm less sure about. There's an exemption when people are communicating internally. That's been with your members. So if you're a nonprofit and you're just communicating with your the members of your nonprofit, and also if somebody is a funder of a nonprofit under the current language and pays regular dues, let's say that funder would not trigger the reporting itself. The one thing I will add, I mean, this is a policy determination, obviously, that the Commission should make. The one thing I would add is that there definitely have been, in our interested persons meetings, concerns about some entities that are nonprofits engaging in this activity. Likewise, just as a practical matter, you do always open up the possibility, if you do exempt a nonprofit, that people will start conducting this activity deliberately through nonprofits. So that it's a balance, and it's certainly a policy consideration for the Commission.
I would just have to say that for the totality of the engagement of nonprofits for the totality of nonprofits that engage with the City and County of San Francisco, the vast majority of them are not that. So I just want to say that we could very much scorch the earth in order to achieve trying to take care of one small thing. So there could be some, I just want to bring to light that there are some serious unintended, or as we've discussed them and brought them to light, intended consequences that are here that I really feel we need to pay attention to.
Do I hear a motion?
Yes, I move that we put this on the ballot with the friendly amendments that we've had from Commissioner Herr.
Is there a second? I'll second.
Yeah, just apologize to jump in here, but I'm not sure whether we actually came to a conclusion a lot of the I guess, problem areas identified by Commissioner Herr. Certainly with, for example, just the sole issue activity expense, we outlined a couple potential options, and we didn't actually, I don't believe, the Commission actually reached a decision on which of those options it prefers. So I think there's a few outstanding issues with respect to Commissioner Herr's.
Well, it was, I understand what Commissioner Keane was saying, is he specifically agreed to two changes that were suggested by Commissioner Herr, that he was agreeable to being made, and he did not necessarily indicate his agreement to the other suggestions that were made by Commissioner Herr. So as I understood his motion, it was to approve it as drafted with the two amendments that he said he was prepared to accept.
Yes, and as I recall, perhaps Commissioner Herr will correct me, Commissioner Herr actually offered language, specific language only for those two. There was sort of ruminations and comments that were made, but no actual language that I could.
Well, that's true, that I didn't propose language for all the proposed changes. But my understanding, Commissioner Keane, was that you were in agreement with me that we need to do something about activity expenses because otherwise it doesn't capture the very concern that we have in that section.
Yeah, that's true. And what I would, well, I guess it would be Commissioner Herr's. We had those two options that were put forth. The third one was no good because it also affected contact people. And what was the second? The second one was the one that I found attractive.
Right. So according to my notes, there was one friendly amendment that you were already amenable to, Commissioner Keane. That is moving the phrase clause directly or indirectly within the definition of expenditure lobbyist, up from page 5, line 6, to the preceding line to follow the phrase "who makes payments." I believe that was one friendly amendment you were already amenable with, Commissioner Keane.
Yeah.
The second one, if it's about activity expense, it would be helpful to have a little more clarity about which route you wish to take.
Well, that's why I'm asking. You then told us of three options, and the third one was one that affected contact lobbyists, so we said, no, that's not the one. But I can't remember the language of the second one, but I recall as you were outlining them, it was the second one that had some appeal.
Right, so the first one was just to remove that reporting obligation altogether. The second was to, I guess, have a different 3-month time span or some other time frame in which activity expenses would need to be reported for an expenditure lobbyists.
I think for simplicity, I'd propose we amend it to the first one, which just takes it out then. So rather than to get hung up on it, so we don't have to then continue to get caught up in drafting.
Okay, so those are the two friendly amendments for the purpose of your motion.
Yeah, I would not support it with only those two amendments. I do think we need the change to 2.103, cutting out the superfluous language from the amendment or repeal in section 2.103A.
Mike, please.
I am speaking into the mic. And I would also not support it unless we had the proposed amendment tying the public relations, media relations, reports, analysis, et cetera, to the actual communication, that there has to be a nexus between the two. And I thought that, Commissioner Keane, you were agreeable to that as well.
Yeah, I accept those.
Okay, so there's 4 friendly amendments then, again, just to clarify. So removing the additional language of 2.103, tying the public relations, media relations, et cetera, to actually urging the public to directly lobby their officers, removing the reporting of activity expenses from the monthly disclosures for expenditure lobbyists, and fourth, moving the phrase directly or indirectly, as I previously mentioned, the definition of expenditure lobbyists. So those 4 amendments.
Those are all accepted.
Thank you for the clarification.
All right, so the record, your motion is, so the record is clear that we we agree to going forward with the proposed expenditure lobbyist as contained in the proposed ordinance with the 4 amendments to it.
Yes.
All right. And I seconded, and I'll second it with the 4 amendments. And I guess I would call for public discussion.
Larry Bush for Friends of Ethics. I would just like to remind the Commission that a few years ago you forwarded a measure to the board, which they then put on the ballot, which eliminated any explanation of what constituted furthering the purpose of the act, and it was overwhelmingly defeated and opposed by every group in the city, from the Republican Party to the Democratic Party, from Green to Sierra Club to Milk to Toklas, you name it, every group opposed it. And that's why this language is in here, and it is not superfluous. If this language is not in here, it will be defeated in November. You will have done all of this for nothing, because no one trusts what it means here when you say it furthers the purpose of the act. For example, you all took the position that it was okay not to have reporting on contracts that went to the Commission from city officials. And the opinion was that that freed up other staff time, so you didn't need to take the time to do it. No one agreed with that. You simply did it. The whole reason you're having to go through all of this on a line-by-line edit is because an earlier commission wrongfully and inadequately changed the law without ever discussing what the implications were. And what were those implications? Well, look at the Chamber of Commerce. They said the Chamber used to be considered a registered lobby entity that was required to report all contacts with public officials, and the issue was involved. But the Board of Supervisors changed the law last year. That was the law that was passed by this commission in 2010, and it gutted any reporting from groups like the Chamber of Commerce. You have not fixed it. We are trying now to fix what was done wrong in the past, and if you fail to do so, it will be a problem for this commission. I would also like to point out, in terms of the issue of nonprofits, I think you are confusing 501c3s with 501c4s, because 501c3s are able to lobby. They can spend a certain percentage of their funds on lobbying. They have to report that to the IRS. Are you saying to the city of San Francisco that that has to be reported to the IRS, but we don't have to report it to the people of San Francisco? That's nuts.
I'm Bob Planthold. I wanted to advocate for passing this pretty much in the form as it is. Again, we're just going back to what was once in effect, and when it was in effect, the sky did not fall, city government did not freeze up. I think it's inappropriate to talk about the speculative problems now when they didn't happen before. One reason to pass this is we've heard the example of Airbnb, but let's go back and look in your own data that the charts your agency showed on lobbying expenditures showed for 6.5 months in 2014 they spent $604, yet a paid staffer was in the Board of Supervisors chambers talking to different people, was out in the hall talking to different people and reporters, was talking to people and planning commissioners. The point is, that's a dubious claim that they only spent $604. Well, with that precedent, why couldn't a big developer and a big contractor and an architectural firm that designs high-rises, why couldn't they also start to put money into developing astroturf groups? You've got to nip this in the bud. That's one of the benefits of this. And I want to go now to 2.103. I think there's a parliamentary procedure thing you may have overlooked or missed. With regard to the claim of Commissioner Keane accepting swapping directly or indirectly from line 6 to line 5, I heard it, he accepted it putting in after who in line 5. I did not hear a specific assent to taking out directly or indirectly from line 6. We heard you folks couldn't come up with an example. Well, what if Airbnb posted an analysis on their website proclaiming all the benefits they provide the city and the residents and all the problems with regulations? And then they said, we encourage you to monitor news stories as this develops and make your views known. Well, some might post it on our Facebook page. Some might write a letter to the editor, and some might call their supervisor or the mayor. That's indirect. It doesn't say, we urge you to talk about this legislation. We urge you to contact your supervisors or your city officials or planning commissioners. So there are indirect reasons, and that's why if you take out from line 6, the directly or indirectly only applies to making payments. Look linguistically. Directly or indirectly is to making payments, not to communication. If you take out directly or indirectly from line 6, you're going to cause a problem that there will still be this astroturf possibility that developers, real estate people, architects, contractors all can foist on us.
Thank you.
Good evening, Commissioners. Mark Solomon again. I urge you all to forward this to the voters for this election in November. There are some issues raised. Commissioner Hayes mentioned that this is like advertising. Advertising is, hey, come stay at B&B, or hey, come be an Airbnb host. Advertising is not, hey, you need to go ahead and talk to your supervisor so Airbnb gets a better deal. That's political advertising that it is wholly within the purview of this commission to command disclosure upon, and that has to happen here. I think that we need to have findings here so that if things are done improperly, then people have recourse in Superior Court to say, here are the findings, here's what they actually found, here's the requirement under the law. No, they didn't do it right. And we've seen that happen in the past. That's why it needs to be in this legislation that moves forward. As to the nonprofits, it's a really tough nut to crack. Are we going to try to pierce the for-profit corporate veil here, which will just allow people to seek refuge under a nonprofit shell? SF-BARF is a group right now that's an AstroTurf group by people probably being funded by the real estate industry, don't even live in San Francisco, and they're talking about converting into a 501c3 or 4. If that happens, will they go ahead and be insulated from any disclosure under this, even though they continue to seek to influence the law? What's even more disturbing for me as a Mission resident is we have a lot of city-funded nonprofits that have these outreach groups. They'll gin up all kinds of outrage over a political issue that doesn't get resolved with changing city policy to make the issue better. It gets resolved with them getting more money from the city to use to do lobbying, to go ahead and try to gin up public opposition to a thing so they can go ahead and get more funding. That is the essence of corruption, where our tax dollars are used to create the facade of political simulacra that gets translated not into policy but into individual best interests. So I think the key to this legislation, there's got to be some kind of a nexus between taking this kind of independent or lobbying activity and tying it to a nexus to some kind of gain. To the actors who are in this chain of cascade, is there gain that accrues up that chain? And that's really what the nexus that the public interest is in, is are people communicating in the shadows to try to get something out of it for themselves that is not in the public interest. That's what this measure needs to go ahead and encapsulate. And we're moving towards it. It needs to go on this year because we've seen such a rise in this activity that it's really reshaping what politics and public policy looks like in this town. And the board's not going to deal with it because there's that much money. You all are the insulated body that has the power under the charter to send this to the voters. We've seen the polling results. We need to do this. Thank you.
Thank you.
Charlie Marsteller again. Bob Planthold was your former chair of this body under a different constituency of members, but I think his expertise prevails here. We had this law. There was an effort to simplify the lobbyist provisions, and it appears to have some problems, that simplification. Plus, the environment has changed. So while we did not need grassroots reporting back in the aughts, I guess we call it, or in the 90s, then we ended up now seeing a need for it. So there's nothing wrong with changing the law. You also have to keep in mind that there is a dollar threshold here. If you're not happy with that threshold, you can put on a different threshold. But I'm saying that not everybody is going to be captured by this and have to register as a lobbyist. And that includes an awful lot of nonprofits providing pizza on a monthly basis, unless you're running up $2,500 bills in pizza. My concern is this: if you don't put this on the ballot, and this goes to the board, in this political environment, with these types of, what do they call these, sharing economies, which is a bit of a euphemism. If you do that and it goes to the board, it's going to be a political football. If something comes out, it's not going to be the bill you would have written. In fact, it'll be a horrible bill. And you're going to be back here when you're doing your review of the lobbyist ordinance, rewriting that just as we are now. So my view is better to put on the ballot the bill you want than to defer it to the board in this environment. And I'm not talking about an extreme bill. I'm not an extreme person. We're talking about a reasonable reform that's just trying to get registration and disclosure for a new type of lobbying as we had it in the law in the past. That's all we're asking. Thank you.
Thank you.
Patrick Manetshaw. I'm speaking in support of the motion on the floor, although I would have preferred that some of the friendly amendments hadn't even been made or adopted. Scorched earth. You know, if it's covered under state law, if we have any scorching, Commissioner, it's because we have a drought, not because we have a procedure in place to identify improper expenditures. San Francisco is an outlier, and you need to fix it. That's what your job is. I attended the Interested Persons meeting and was quite concerned about allowing the Board of Soups to make any amendments to it. And the reason for that is back in 1989, the voters passed Prop Q, requiring the Health Commission to be notified when healthcare facilities wanted to reduce or eliminate services. The voters passed it, giving the Health Commission a single marching order that they could only reach a finding of whether the reduction or elimination would or would not, using will or will not, have a detrimental impact on health care. For 26 years, that law stood until June 10th, when the Health Commission, in its infinite wisdom and a secret city attorney opinion that they won't release because it's communications, it's not a written city attorney opinion, because the city attorney told me we haven't issued any formal written opinion. The Health Commission overturned the will of the voters, neutering Prop Q. And instead of reaching the single finding of whether it will or will not have a detrimental effect to eliminate 32 skilled nursing beds at St. Mary's, they approved it without ruling one way or the other, in effect overturning the will of the voters. I don't want the Board of Soups having any snowball chance in hell of being able to overturn this. And I absolutely agree with Mr. Marsteller and the rest of the Friend of Ethics. You need to do this tonight. You need to put it on November's ballot, and you need to stop all of this quibbling about nonprofits. Larry Bush is right. If they have to report it to the IRS, they should be reporting it to you too.
Thank you.
Good evening, Commissioners. I'm Bob Dockendorf. I'm a member of Friends of Ethics, and I was on this commission from 96 to 2000. I'm speaking in support of the proposed legislation that you've got before you. And this commission has always had a problem of exerting its power. This commission has a lot of power, and it's been afraid to project that power. It's been subservient. It bows down to all of your appointed officials. It bows down to the board. The charter doesn't say that. You folks have got a lot of power that you need to exert. As Commissioner Andrews pointed out, nonprofits could be a problem. Have a problem. Nonprofits aren't what they were a few years ago. Almost anybody can be a nonprofit today and hide under all kinds of legal jargon. So it's not the same group who are going after city funding, and unfortunately most of our nonprofits are reliant on city funding, city and county funding, because they don't have the contribution base out there to be self-sufficient. You've got 800,000 people plus in this town now, and you're the only wall between them and about maybe 800, 900 lobbyists, many of who don't even live in the city. You need to protect the citizens of San Francisco, and you folks are the only ones that can do it, and you have the power to do it. You just need to do it. Thank you.
Mr. Chairman and members of the Commission, my name is John Sinclair. I've been a resident of San Francisco since 1986. During the course of the last year, I've become very concerned about the influence of money on local politics, especially in the debate concerning Proposition G, which sort of opened my eyes to what actually was really going on. I think it is correct that members of the community do know that contributions are being made and lobbying efforts are being made from outside sources. What they don't know is the magnitude, and magnitude matters. When I write a check for $100 for a local campaign, I've got to disclose my name and the amount of the contribution. If large corporations are making $20,000, $30,000, $40,000, $50,000 lobbying efforts per month, then I think we're entitled to know.
Thank you.
My name is Sue Hester. I'm an attorney who deals with land use and good government things in the city. And it has evolved that there is a lot more hidden today than in the past. As a lawyer, I did continuing education this past week about the effects of Citizens United decision. The whole landscape in the country was changed by the Supreme Court, and people are romping to death all over the country. They're able to hide expenditures. They're able to do lobbying, as long as it's not through a candidate. So people and corporations and entities are having their will in the United States right now. They shouldn't have it in San Francisco. You have a responsibility, and other local governments and California has a responsibility to have strong laws. You are the people that have to state that this kind of effort needs to be disclosed. You're not the Supreme Court, but at the local level needs reporting. I listen to commercials on the radio all the time. I listened the past week. You would think pansies are growing, puppies are being held by nonprofits, a non-disclosed interest that are saying, oh, I get to stay in the city because I can host people. And at the same time, I'm very well aware that most of the hosting that is done in the city is not done by my neighbor down the block. It's done by taking units off the rental market and decimating the rental stock of the city. That's just one example. You have a responsibility and you have power. You should use your power to put this on a ballot and give the people of San Francisco the right to say there needs to be more disclosure in San Francisco. It's been taken away at the federal level, but we're not the federal government. We are San Francisco, and we can do it right. I would ask you to put this on the ballot and be very careful about watering what is before you in this written version. Don't water it down. Thank you very much.
Thank you.
Good evening, Commissioners. Anita Mayo from Pillsbury, Winthrop, Shaw, Pittman. I would like to make a few comments on the proposed ballot measure regulating expenditure lobbyists. As I've testified before, most lobbying in San Francisco is accomplished through the payment of compensation to individuals to lobby city officials directly. The expenditure lobbyist category was deleted from the lobbying law in 2010 because, in part, very few individuals or entities qualified and submitted reports as expenditure lobbyists. Since it appears that you have decided to move forward with adding back the expenditure lobbyist category to the lobbying ordinance, I would like to thank Commissioner Keane and city staff for simplifying the definition of expenditure lobbyists in the proposed measure. The current definition provides more clarity over the previous versions and is consistent with the terminology provided in the lobbying laws of many other local California jurisdictions. I would like to bring to your attention one matter that has not been previously discussed. Since the term expenditure lobbyist, as currently drafted, will apply to any person who makes payments aggregating $2,500 or more in a calendar month to urge others to lobby city officers regarding local legislative or administrative matters, this law may apply to developers of major projects in San Francisco who are already required to register, pay a $500 fee, and file 5 reports with the Ethics Commission. Under the Developer Disclosures Law, a major project is a real estate development project in San Francisco where the Planning Commission or other local lead agency has certified an Environmental Impact Report, or EIR, under the California Environmental Quality Act, or CEQA, and the estimated construction cost exceed $1 million. Within 30 days of the EIR certification or the adoption of a final environmental determination under CEQA, the developer must pay the $500 fee and file an initial report disclosing, among other things, a nonprofit to whom the developer and its affiliates have made cumulative donations of $5,000 or more since the date 1 year before the environmental evaluation application was filed, if that nonprofit has made one or more contacts with city officers or testified at city hearings regarding the developer's major project. The developer must then file 4 additional quarterly reports with the Commission. Since developers of major projects are already required to register and file reports with the Ethics Commission, it would impose a tremendous burden on developers to also have to register and file monthly reports as expenditure lobbyists. I therefore urge you to exempt from the proposed ballot measure those developers of major projects who are subject to the registration and reporting requirements of the Developer Disclosures Law. And one final comment. Regarding the nonprofit issue, there was a consensus at the interested persons meeting that all individuals and entities, including nonprofits, should equally qualify as expenditure lobbyists, and that the burden should not fall primarily on profit-making entities. Thank you.
Commissioners, Ellie Abdoli with Nielsen Merksimer. I urge you to continue these great discussions regarding this legislation and not rush to place this on the ballot immediately. I have no issue with it eventually going on there, but I think this discussion, as well as the IP meeting, shows how important it is to talk about the consequences, how the law can impact different bodies. With all due respect to Commissioner Keane, you are the legislative body here. You're drafting something that, while I get we shouldn't get caught up in every nuance, these aren't little nuances. These are big issues that we're discussing. With respect to the balance, while I get targeting the Ubers and the Airbnbs, the onus that it's going to put on nonprofits may not make sense in the balance. And these are things that we should talk about. We should continue to discuss what the implications are. There was some discussion about, well, we're just going to the previous scheme. We're not exactly going to the previous scheme, lobbying regime, sorry. We're kind of picking little parts from the previous lobbying regime, and those parts don't necessarily fit well together. We're hearing, there's some issues of double reporting. I would think that in some ways, the Airbnb who hires the big fancy lobby firm that's going to be, putting these ads up and doing all this information, they're just going to be filing as contract lobbyists and only disclosing the compensation they're paying to that firm, whereas the nonprofit is going to have to itemize every expenditure at $1,000. We're not putting these people on equal footing. So I'd encourage you to continue the discussion. There's no rush. I'm hearing stories from the 80s, so I'd encourage you to take a couple more months. Frankly, I don't even know if it would take that long, maybe another meeting, and hash it out this time. Let's get it right, and let's put something that's really going to work on the ballot or before the board. Thank you.
Thank you.
Good evening, Commissioners. My name is Chris Wright, and I'm the Executive Director of the Committee on Jobs. I'm also a registered contact lobbyist. Just to, refer to some of the comments that were made before, I'm very concerned about double reporting. As a contact lobbyist, I have to file, which is fine. I love the net file system. It's great. I would hope that the Commission and the staff are empowered in this legislation to make it as seamless as possible so that we don't have to file we don't have to file paper reports or have to pay another fee or whatever. It should be all incorporated within that net file system that we currently have. I also want to point out that an issue on Section 2.110 on which is page 11, lines 11 and 12, when it refers to lobbyists in a corporation, the name of each officer of that corporation. That could be a lot. So let's say you are a Tier 1 bank. You have offices all over the globe. You want to put 2 ATMs in a neighborhood commercial district. Under the current rules of planning, you had to get a conditional use permit to do so. That involves bringing the community together, having neighborhood meetings, getting people involved and engaged. I'm not sure if it's necessary to have all 2,000 or so officers to be submitted to the Ethics Commission. I'm not sure if you need the head of human resources to be listed. I'm not sure if you need the head of the accounting to be listed. There's probably a way to reduce that so that you know who you're going after or who you want to have report. That goes to, I think, the comments that were made earlier by Commissioner Herr that say that you don't want all 2,000 officers at a bank to be filed. Under the initial draft, any less disclosure would have to go through all sorts of hoops and hurdles. It's important to get this done right the first time, and I would ask that you review that one portion. And just a comment on the Airbnb. I know there's been a lot of discussion about these commercials. I'm not an attorney, but I don't think that the commercials, as they're currently being played, I haven't heard one, would not be included, would not be covered by this legislation.
Can I, will the Chair indulge me for 1 second? What would you propose instead of the current language on lines 11 and 12?
The name of the officer who controlled the expenditure, or something to that, who authorized the expenditure, or just the name of the company. I'm not sure, but I don't think you need every officer of a large business.
Thank you.
Good evening. I'm Sharon Zaslavsky. As a former ethics director from 2000 to 2003 and a friend of ethics, and in the interest of time, Commissioners, I strongly urge support of this measure for the November ballot. The Ethics Commission has the power, and I urge you to use your authority and place the measure on the ballot in November. Thank you.
Thank you. Any other comments? I will call the question, and I will say for the record that the reason why I seconded and why I supported is primarily because it only brings us in line with the other local ethics commissions and jurisdictions in California, and it does reestablish what was the rules in San Francisco prior to the simplification of the lobbyist thing. Any other comment before
Just a couple, Chair Rennie. One relates to the proposal that was just made. I mean, I do see a lot of sense to a situation where you got to put down the names of 2,000 officers. I mean, what if we had an amendment to page 11, lines 11 and 12, that limited the officers to C-level officers and the officers who authorize the expenditures? That way, you're getting the main officers of the corporation and the people who actually were directly involved with the authorization.
I accept that as a friendly amendment.
Sorry to interject. Just to clarify the amendment, when you say C-level, I'm sorry. That's not a term I'm not familiar with. It's like just the letter C.
Chief executive, like a CFO or a CEO or a chief operating officer. They're
the C's.
The C's.
That's top tier.
What would be official terminology?
Right. So would you recommend actually including the term C-level? Is that like
no? We would probably need something less colloquial.
Yeah, apologize. I'm just not familiar with the term.
You would you could do an and/or, and I would leave authoritative. Who authorized the expenditure? I would just probably put that. I would put C-level or and/or a person who authorized the expenditure.
Yeah, my intent would be to include both, but I'm not sure C-level is in the actual legislation would be the appropriate term. I mean, is that something we can work out?
Well, they're officers, is what they are. I mean, they are officers of the organization.
Corporate officers.
They're corporate
officers.
That's what they are.
Clear enough?
Is that?
They're corporate officers.
Corporate officer would be
if
like
you were doing,
CEO, CFO, COO.
Yes, like if you had directors and officers insurance, officers are generally all of the C types, CEO, CEO, CIO, CAOs. So it's a corporate officer.
Should we put, this is the joy and danger of doing things on the fly, but you could say each corporate officer parens, for example, CEO, COO, CFO.
What line is it that you're proposing to modify?
Lines 11 and 12 of page 11.
Just by way of suggestion, although this is just coming to my head, I know generally in terms of California law for corporations, you have to have a CFO, a CEO, and then a secretary, I guess. You probably wouldn't, I don't know if you want a secretary or not, but it could be those three, for example, and then you could add in the person who actually was in charge of making the expenditure. That would give you the top three, but it wouldn't give you CIO, for example, or CTO, or
CAO, or
you could
administrator.
Like authorizing executive.
Yeah, I think that makes sense. Maybe it's CEO, did you say CFO, secretary?
The authorizing.
And the officer who authorized the expenditure.
Yeah, sure. I think that's right.
That's accepted as a friendly amendment, Mr. Chair.
My other question for the group and comment was, I accept what Commissioner Rennie said, that we can't fix everything or legislate everything in the actual ordinance, that there are going to have to be regulations that implement it. But as direction to the staff in implementing the regulations, I do think we have to think very hard about how employees of nonprofits, for-profits, whoever, are counted in this. Because clearly this contemplates them being counted, and I accept that. But I think we need to really think hard about how they're going to be counted and give sufficient direction to for-profits and nonprofits so that they know how they're going to be counted and how they should count employees to properly report.
All right. I'll call the question. All those in favor?
Aye.
Opposed? Hearing none, it's carried unanimously, 5-0. Turn to item number 5, discussion and possible action regarding commission responses to the 2014-2015 civil grand jury report relating to whistleblower protection.
This report was issued a couple of weeks ago, and the Ethics Commission is required to respond. This is, I think, fairly straightforward. The civil grand jury is recommending that the Commission endeavor to make changes and improvements to the whistleblower ordinance. If the Commission adopts the draft language that I've presented, the Commission will be committing to taking on this project. I expect it to be some heavy lifting, and it's going to require the cooperation of at least 4 departments. But we would endeavor to do this in 2016.
Any commissioners have any comments on the proposed responses that the staff has prepared to the recommendations? All right. Okay. Call for any public comment.
Good evening, Commissioners and Mr. St. Croix. My name is Dr. Derek Kerr. I'm a whistleblower. I brought my complaint and my retaliation complaint to the Ethics Commission in 2010. All of them were dismissed. I sued the city, received a $750,000 settlement, plus the city had to spend $450,000 in city attorney fees, a $1.2 million hit for the taxpayers. Ethics Commission records show that whistleblower claims have been investigated since June of 1995. So in the intervening 20 years, some 60 retaliation complaints have gone through the Ethics Commission. Not 0 have been substantiated. And that's in distinction to the international benchmark issued by NAVEX, a big corporation that studies 8,000 whistleblower hotlines. The retaliation sustaining rate is 10% internationally. Here, 0%. So this startling statistic suggests to me that the Ethics Commission has been complicit in the repression of city employees who break ranks in order to serve the public interest. This commission has been a dead end for whistleblowers for a number of reasons. First of all, you view whistleblowers as threats, not assets. Your investigations are superficial and dilatory, and they're aimed at exonerating respondents. That's the intention. Instead of being independent, you submit to city attorneys whose duty it is to defend city officials who are exposed by whistleblowers. The city attorney is opposed to whistleblowers. Also, your staff is afraid to substantiate retaliation allegations because if they did, they would face budget cuts and layoffs. They would be treated the same way whistleblowers are treated, as threats. So, nonetheless, if you continue to reject and bury retaliation claims The whole operation is unethical and incredible. So please start by implementing the civil grand jury recommendations. But beyond that, what's really needed is a change in attitude, namely starting to view whistleblowers as potential assets instead of as potential liabilities. Until that happens, I would recommend avoiding the Ethics Commission and taking whistleblower concerns directly to the public through the media or the courts. Thank you very much.
I'm Patrick Minette-Shaw. I'm really hoping that the Ethics Commission will find a way, since you just passed putting a ballot measure on regarding expenditure lobbying, that you will find a way to put a measure on the ballot to strengthen the whistleblower protection ordinance. Because my hunch is, under the current environment at the Board of Soups, they are not going to take action. I've just finished up my new article, which focuses on the ugly truth that retaliators keep their city employment, while those who are wrongfully retaliated against do not. I followed up with the city attorney's office. Dr. Kerr had submitted a records request back in 2012 seeking records on prohibited personal practice lawsuits that had been filed against the city. At the time, I wrote an article in April 2012. There were 105 such cases. In the last 3 years, under Mayor Edley, it has soared, and another 187 cases have been added for a total of 292. Of those, while there have been only 14 wrongful termination cases between 2007 and 2012, there have been 23 settled in the last 3 years. There are 9 still outstanding, for a total of 46. We have an epidemic of wrongful termination in the city, and you need to do something about this. The retaliators should not be keeping their jobs, while dedicated civil servants like, let me find a few names, like Derek Kerr and the woman at the police commission who was fired by Greg Seward, lost her job. Kelly O'Hare. Then there's Joanne Hepper over at the city attorney's office. You really need to find the ethical courage to strengthen our whistleblower protection ordinance.
Thank you.
Yourself.
Good evening, Commissioners. Elena Schmidt. Also Friends of Ethics, but I'm here as the past foreperson of the 2013-14 grand jury. And I'm sorry there's not a representative of the current jury, so I will speak to a couple of matters. I do appreciate that the jury whose service just ended, the 2014-15 jury, picked up our recommendation to look at the whistleblower aspect and to strengthen it. And it's a good step in the right direction. I appreciate staff's draft that they presented you in terms of responding to the recommendations, and that the responses seem to mainly be positive responses, that you're willing to look at the recommendations and see what you can do. But it's fairly vague. And I just want to remind you that once you have a recommendation from the civil grand jury, you do have a certain obligation to answer with specifics. So the way the California Penal Code Section 933.05 reads is that if you are not saying that it's unreasonable, if you are saying that you're not going to do it, if you in fact saying that you are doing it, which is what you're talking about, you have the recommendation has not been implemented, will be implemented within a certain amount, within a set time frame. So if it hasn't been implemented, there's a time frame that you should be responding to say you will have it implemented by such and such. Or number 3 is the recommendation requires further analysis. The officer agency head must define what additional study is needed, and the grand jury expects the progress report within 6 months. So as I read the drafts, responses that you have, recommendations that you have in front of you, I think that's basically where you are, which is that it needs further analysis. You don't have all the information that you're going to need or the language or the issues you'd be looking at. So I think you need to lay out a bit of a game plan to basically respond to the grand jury via the Board of Supervisors to say, within 6 months, this is what we're going to be able to do, and then moving forward, we'll give you periodic updates. Thank you for the chance to talk.
Thank you.
Commissioners, Charlie Marsteller again. I did want to let you know that in the past, when the consistent difficulties with the Sunshine Task Force and how this body was going to proceed to handle complaints from that were referred to you by that Sunshine Task Force body, what you did was delegate it to Commissioner Harriman, who was former president, and she went to work as a subcommittee of one, I believe, and came up with a set of recommendations for you to, as a body, how to proceed with dealing with Sunshine complaints that have been referred. The same could be true with the whistleblower. That process could apply here as well. You can appoint a subcommittee person to take a look at what this body does with whistleblower complaints and what you could do better. I think Commissioner Harriman spent some time on that question of the Sunshine Task Force. It may have been a year, actually. But she did a great job. So I would hope for the same with the whistleblower, because I think it's a loose end. And now that you're almost 20 years old, it's about time we grew up.
Thank you for your comments, and you have anticipated I'm going to see if I can get a volunteer. Any other public comment? Any further discussion among the commission? I am going to ask if anyone wants to volunteer, just as Commissioner Keane did with the legislation we just discussed, but would like to take on as a task to assist in responding and preparing some response